Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome. Sorry I had to push the time back. My internet actually went out, or I guess in the neighborhood, actually. Spectrum, not the greatest, but it's what we have over here for internet. Anyway, so had to wait for that to come back, so that was fun. Also missed a couple lessons, but anyway, at least it was only out for a couple hours. It's been worse. It's been worse, so glad it's back now. So we still plan on doing everything as planned. We're going to go through the latest here for Karen Reed. We're going to watch some important things here that come up in the court filings and were mentioned in the hearings. And also this should redirect you guys through the magic of technology into the next live stream with all the next of the BK docs that we're going to be doing. So yeah. So shout out to Leslie and Billy. Shout out to Twiz. Twiz hasn't been eaten by any birds yet, so that's some good news as well. I feel like I had all this other stuff, like news and whatnot, but then I got all thrown off with the internet, and now I don't remember what it was. Anyway, I'm sure I'll think of it if there was something. So first things first, though, surprisingness. Surprising news, or like, this is surprising. Judge Bev, okay? This is surprising me here, okay? So here we go. Memorandum of decision and order on Commonwealth's motion to impose sanctions pursuant to misrepresented and oral motion to prohibit prejudicial extrajudicial statements of counsel. Now, when we talked about this during the hearings and whatnot, you know, it seemed like if she found for sanctions, remember, there were like a number of different issues that ended up being discussed for sanctions. So there was like the extrajudicial statements, right? And then there was like the thing with the interviews, and kind of what I was thinking was, that what she would probably end up doing is that she would probably end up just telling them they can't give any more interviews prior to the trial. And why was I thinking that that's the case? Because if she were to do anything more drastic than that, she would be risking, guess what? Needing to push back that trial date. And above all else, she wants to go to trial on April Fool's Day because she's a fool. So just kidding. I'm not kidding. And so I figure that would be a likely scenario, would be for her to tell them, don't do any more interviews. While that is reasonable, the most reasonable option, it would be not because it's reasonable, if that makes sense. But also I thought to myself, like, it's not like they will have time. Like, they shouldn't be doing it anyway. Like, how the fuck, like, I think it's 26 days until trial at this juncture. So anywho, Twiz is only typing with one hand. Uh-oh. You have a bloody stump of a wrist over there. So anyway, okay, so let's all be surprised. So memorandum of decision. Oh wait, I already read that part. Okay. This is the background here. We already know. The matter is set for retrial on April 1st, 2025. There have been more than 500 filings in this case. Yeah, this is number 555. Many of which are subject to protective orders. This case has generated significant media attention locally and nationally, with the defendant and defense counsel participating in numerous interviews with media outlets. In addition, the court is aware that there was also a federal investigation into the investigation of O'Keefe's death. Recently, the Commonwealth represented in open court that the federal investigation has concluded without the issuance of any indictments. Yeah, I guess we're going to just take that for what it's worth. Before the court are two motions. Okay, the Commonwealth's motion to impose sanctions pursuant to Massa Crimp 48 and an oral motion made by the Commonwealth to the court on March 4th, 2025, renewing its prior written motion seeking to prohibit extrajudicial statements of counsel that would have a substantial likelihood of materially prejudicing these criminal proceedings. Okay. For these reasons that follow, the court will deny, you heard it right, guys, deny the Commonwealth's motion for sanctions. Wow. Under Massa Crimp, and allow the Commonwealth's motion for an order limiting extrajudicial statements of counsel. So just to reiterate, Judge Bev is denying the Commonwealth's motion for sanctions and allowing the motion for limiting extrajudicial statements. Again, what is that going to be? Well, she's going to lay it out, but it's going to be something like I was just suggesting, right? No more freaking interviews type thing, right? Or something to that effect. So yeah, isn't this wild though? Isn't this wild? After the rulings we just saw happen, it's shocking to me. We'll see what tomorrow brings though, right? Remember, like I said, her motivation is getting to trial. That's it. That's her motivation. She does not give a fuck. She wants to go to trial on April 1st. That's her motivation. All right, discussion. I mean, she's not going to say that, right? Discussion. Commonwealth's motion to impose sanctions pursuant to Mass Arc 48. So pursuant to Mass Arc 48, a willful violation by counsel, of the provisions of the rules of criminal procedure or of an order issued pursuant to these rules shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition of costs or a fine. The purpose of Rule 48 is to allow judges, quote, to regulate the conduct of attorneys who practice in the courts of the Commonwealth and to discipline those whose actions fall short of accepted standards. In addition to the sanctions of citations for contempt and the imposition of costs or a fine, the rule contemplates referral to the Board of Bar Overseers where appropriate. The Commonwealth's motion for sanctions is in response to the defendant's motion to reconsider reciprocal discovery order, wherein defense counsel quoted information subject to protective orders issued by this court on November 13th, 2024 and January 31st, 2025. Attorney Yannetti has acknowledged that this motion, which was not protected from public view, should not have included protected information. However, he represents that the inclusion of protected information was a mistake and not a willful act. Now that matters, right? Because when it comes to sanctions, right, this is the whole thing, right? What is the culpability here? Now, what's so interesting is as I'm reading this, I'm like, yeah, I know this is the standard, but this is Judge Bev. And you know Judge Bev is going to find it willful wherever she can. She's going to fuck the defense wherever she can. But not when we're only 26 days away from trial. That's the thing, right? Same thing with these experts. She's just going to rubber stamp everything. You know what? Because she did not schedule any time for voir dire. You know? Okay. Same goes with the evidentiary hearing. So he represents that the inclusion of protected, right, okay, a mistake and not a willful act, right. As a sanction for this conduct, the Commonwealth requests that the court issue an order that the defense, quote, file all motions under seal and impound it until such time that both the Commonwealth and court can ensure that the filings comply with all previous orders set by this court. Now, that's a more extreme measure. The sanction sought by the Commonwealth is not appropriate under Rule 48. Rule 48 allows for the imposition of punitive sanctions on individual attorneys who intentionally violate the rules of criminal procedure or the court's orders. Again, to me, I'm shocked that she's not finding that Yannetti intentionally violated something, right? I mean, seems like if maybe this was a few months out from trial, maybe she would find that way, right? So, okay. So here it says sanctions that may be imposed include a citation for contempt or the imposition of costs or a fine or referral of the matter to the Board of Bar Overseers. Although procedural remedies such as the initial impoundment of documents sought here are available under other rules of the court, defense counsel has assured the court that it will take more care in the future. I mean, this is hilarious, right? She's like, yeah, I'll give you the benefit of the doubt. Wow, what? Defense counsel has assured the court that it will take more care in the future with protected information in court filings. The court therefore declines to impose any sanction under Rule 48 at this time. However, subsequent and/or repeated violations of court orders may well be considered either willful conduct or careless indifference that warrant sanctions by the court as permitted by the rules. Okay, now here's the second part of this. So the Commonwealth's motion to prohibit extrajudicial statements of counsel. Few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. Thus, restraints on extrajudicial statements by counsel may be warranted in a particular case to protect the integrity and fairness of the judicial system. However, the regulation of attorney speech is limited. It applies only to speech that is substantially likely to have a materially prejudicial effect. Consistent with these principles, a court may issue a gag order which restrains the speech of participants in the proceeding if the order is justified by a, quote, compelling state interest to protect against a serious threat of harm and is no greater than is necessary to protect the compelling interest. So it's one of those situations, right? They have to use the least restrictive measure. Such an order must be supported by detailed findings of fact that identify a compelling interest that the restraint will serve and demonstrate that no reasonable, less restrictive alternative to the order is available. The Commonwealth seeks a gag order to prevent defense counsel from making extrajudicial statements in violation of the Massachusetts Rules of Professional Conduct and from revealing protected information to the public through the media. In June 2023, the Commonwealth filed a similar motion to prohibit prejudicial extrajudicial statements of counsel in compliance with the Massachusetts Rules of Professional Conduct. The court denied that motion, concluding that no trial date had been set and that this minimized the likelihood that extrajudicial statements would materially prejudice the proceedings. In so ruling, however, the court emphasized that all counsel are bound to comply with the standards for attorneys with respect to extrajudicial statements. The court also made clear that neither party should interpret this decision as precluding a future court order limiting counsel's statements. She's like saying, I can still limit them. Don't get your hopes up, people. At the March 4th, 2025 hearing on the Commonwealth's motion for sanctions under Mass Article, the Commonwealth reasserted its request for a so-called gag order, arguing that defense counsel have violated Massachusetts Rules of Professional Conduct by making extrajudicial statements that counsel reasonably should know will have a substantial likelihood of materially prejudicing the proceeding in this manner and have put protected information into the public domain. In support of its oral motion, the Commonwealth asserted that the defense lawyers have a history of making extrajudicial statements that may prejudice the proceedings. It also submitted audio clips from an interview conducted by Boston Magazine reporter Gretchen Voss of the defendant and Attorney Jackson at the Omni Seaport Hotel on July 13th, 2023. And then we have a footnote. Although this interview was conducted on July 13th, 2023, the Commonwealth only recently obtained the audio and shared it with the court. And cited to a recent interview aired on February 17th, 2025, that defendant Attorney Jackson gave to Fox 25 News. Footnote 2. At the hearing on the motion, Prosecutor Brennan also stated that Attorney Yannetti appeared on CourtTV falsely representing the subject of the federal investigation. In fact, CourtTV played a clip of statements Attorney Yannetti made on a Zoom hearing in court. Thus, contrary to the Commonwealth's representation, the statements were not extrajudicial and thus are not considered for this motion. Don't worry, we're going to take a look at that here in a second. Based on these interviews and defense counsel's consistent publicly reported interactions with reporters and bloggers throughout the first trial, the court agrees with the Commonwealth that an order limiting extrajudicial statements of counsel is both appropriate and necessary to ensure a fair and impartial trial, and finds that no reasonable, less restrictive alternative to the order is available. During the Voss interview, the defendant, with Attorney Jackson seated at her side, told the reporter about witness testimony from the defendant's sealed grand jury proceedings. Specifically, while discussing Voss's recent visit to the Waterfall Bar and Grill, park the cots at the Waterfall Bar. Sorry. The defendant stated that the bartender who works there had testified before the grand jury. Ruh-roh. After further conversation, the defendant then told Voss the substance of the witness's testimony before the grand jury. Ruh-roh, even more. The requirement that grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth. In order to protect the process from extraneous influences, protect individuals from notoriety and disgrace, protect witnesses from intimidation and subornation, and encourage the free and full disclosure of information concerning commission of a crime. It specifically prohibits anyone other than a person performing an official function in relation to the grand jury from disclosing matters occurring before the grand jury, except in the performance of his or her official duties or when specifically directed by the court to do so by the court. Although Attorney Jackson did not himself disclose information about the grand jury proceedings to the reporter, he had two opportunities to intervene to prevent his client from disclosing such information. Instead, he sat idly by, while his client disclosed to a reporter the testimony given in grand jury proceedings. Additionally, during the interviews with both Voss and Fox 25 News, Attorney Jackson disparaged witnesses in the matter. In the Voss interview, he specifically referred to the two witnesses liars. Statements commenting on the character, credibility, or reputation of witnesses are more likely than not to have a material prejudicial effect on the proceeding. In the subsequent Fox 25 interview, Attorney Jackson claimed that, 1, although individuals involved in the case know what really happened, they're not talking, and 2, witnesses in the Albert home in the night of January 28, 2022 had obtained lawyers for self-preservation, which implies that they are not being truthful in their statements to law enforcement about what occurred. Well, I don't know that just simply obtaining counsel implies that they're not being truthful. However, there's plenty of other behaviors taken by the McAlberts that would imply that they're not truthful, my opinion. And we had a footnote here, footnote 3. So footnote 3 at the bottom, the court also notes that Attorney Jackson had a conversation with Voss at Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery, but not yet made public. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he had received in discovery, and told her she could not publicly disseminate the information until it was put into a court motion. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing so the reporter could put it in her article before publication. Okay. I mean, we don't have, I feel like we need more information on that. But anywho, in the decision on the Commonwealth's first motion to prohibit extrajudicial statements, the court stated, quote, that defense counsel statements to the media had at times arguably crossed the line of permissibility under Rule 3.6, but concluded that the risk of prejudice was minimized by the fact that no trial date had been set. With trial now imminent, and with the above-mentioned examples of improper statements made directly or indirectly by defense counsel, the court is no longer satisfied that the less restrictive alternative to the order previously given, the reminder to counsel that they are bound by the ethical and procedural rules, is sufficient to ensure a fair trial in this matter. The court finds there's a substantial likelihood that continued comments about witnesses and evidence in this case by counsel in the future might well taint the jury pool. Therefore, an order restricting such statements is now both appropriate and necessary. So here's the order. For the foregoing reasons, the Commonwealth's motion to impose sanctions pursuant to Mass. Code 48 is denied. The Commonwealth's motion to prohibit extrajudicial statements of counsel is allowed. It is further ordered that 1. None of the lawyers appearing in this case shall release or authorize the release of information about this proceeding that a reasonable person would expect to be disseminated by any means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing potential trial jurors or witnesses in this case. 2. None of the lawyers appearing in this case shall release or authorize the release of information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. 3. None of the lawyers appearing in this case shall release or authorize the release of protected information in this case, including information subject to a protective order or information protected under the rules of criminal procedure. So again, this is so reasonable. It's the most reasonable thing I feel like I've ever seen from Judge Bev. Coming right on the heels of allowing Dr. Crosby and denying Mark Better Parag-Viche. Again, I think she cares not about a fair trial or anything. I think she just cares about going to trial on April 1st. She just doesn't want to be there. I don't know why she has the job. Okay, we have another filing. Oh, sorry. One more rule. Rule number 4. Lawyers appearing in this case shall remain subject to all the relevant provisions of the Massachusetts Rules of Professional Conduct, including Rules 3.6 and 8.4, signed Judge Bev on March 7th. Now we have the next filing. Here comes Hank Brennan. So, April Fool's Day, my twiz. April Fool's Day, April 1st. I counted it earlier today. I think it was 26 days. I think it's in the video description. I believe it was 26 days. Might have been 25 days. April Fool's Day. April Fool's Day. Of course. So this is so crazy because Hank Brennan misrepresented to the court on the March 4th hearing about these CourtTV things. And then Yannetti corrected the record. And then Brennan doubled down and then tripled the fuck down the next day on this. And he did not say anything about the fact that he was incorrect until he was specifically asked by Judge Bev another question like, hey, do you have that cite for me yet? And then he was like, well, I intended to correct the record. And it's like, the fuck? And then he did that thing that was so annoying where he was like, yeah, it turns out it was a Zoom hearing, but they did give an interview afterwards. But he kept throwing that in there as if to make it seem like there was still something wrong with it or that he didn't get it, wasn't mistaken. And anyway, dude, it was just like he kept trying to, it was like not a real, in other words, it was like he was only sorry because he got caught. It wasn't like he was actually, because, the way that it should be with these attorneys, if they misrepresent something accidentally, they're groveling. They're groveling because it is such a big deal. And it's like we get the opposite from Hank Brennan every time. You know, it's like, had he not gotten caught, he would never have said anything. And even when they did bring it up, it took like 3 times for him to finally concede that he was misrepresenting it. He kept trying to change the subject on March 4th. I mean, we pointed it out. It's just crazy. So here he is. So remember when he was like, yeah, I intend to correct the record. It's like, well, you can correct the record now. When were you going to do it if you weren't called out? Anyway, here he is. Here he comes to correct the record, quote unquote. Okay. So Commonwealth's motion to correct record. Now comes Hank Brennan, special prosecutor in the above docketed case, and submits the following affidavit to correct the record. Okay. Here it is. Here's his affidavit. All right. Affidavit of Special Prosecutor Hank Brennan to correct the record. My name is Hank Brennan. I've been appointed by the special prosecutor, and signed as lead counsel for the case of Commonwealth v. Karen Reed. In oral argument, I provided a number of examples of extrajudicial statements that have been made by defense counsel, as well as examples of in-court statements made relative to the now closed federal investigation and the potential impact such statements may have on the potential jury pool. One of the examples that I cited to support commentary about the now closed federal investigation was a statement made by Attorney Yannetti. I inadvertently and mistakenly characterized one of his statements as an extrajudicial statement. The statement by Mr. Yannetti was not an extrajudicial statement. It was a statement made during a Zoom court hearing in the Reed case. So that's not extrajudicial, right? The statement was aired as part of a segment posted by CourtTV entitled Karen Reed's Attorney Talks Federal Investigation CourtTV. The segment included a story regarding the case, and there's the link. Don't worry, we're going to watch it. The 41 minutes and 21 second segment video includes a CourtTV anchor story on the case, Vinnie. Witness interviews include some clips from the court hearing, including court hearing coverage, including a Zoom court hearing. The quote from Attorney Yannetti was a statement Mr. Yannetti made during the Zoom court proceeding in the Reed case. I mistakenly stated that Attorney Yannetti's statement was an extrajudicial statement. My mistake was unintentional, and regrettable. So one of the reasons we're going to watch it is because, one, it's been brought up a lot in the hearings and in these documents. This was referenced a lot. But one, we want to assess, was this unintentional and regrettable? Like, in other words, is this one of those things where if you watched it, it was clear what you're watching, right? You know, that sort of thing. Heather's here. Welcome back. We missed you. We missed you, Heather. Hope you're feeling better. So that's one of the things we're going to be thinking about, right? Is this clearly just a mistake? I mean, you know, okay. And then I think there's more. Is there not more? Oh, wait. Yeah. There we go. That's it. Okay. So number 9, my mistake was unintentional and regrettable. Signed under the pains and penalties of perjury. Sounds like a request for a sword fight or something there, right? The other thing is he kept referencing again comments or whatever statements made after the hearing, after the Zoom hearing, because he kept trying to throw that in there as if to be like, well, they still made extrajudicial statements, you know. So that's what we're going to watch next. And then we're going to watch the latest juror interview. So here it is. Okay, let me just unshare, reshare. I'm annoyed. Why is it like this? Hold on. Let me just fix this real quick. Because this is stupid. How do I, like, what the fuck? Why is it not showing my picture? Like, I don't like this because now, like, what is StreamYard doing? There we go. Because otherwise it's like, if I was like, otherwise I see it and I'm like, oh my God, did the stream die? Right? Anyway. Okay. StreamYard is just changing things around. So I'm sure you guys have probably heard other people mention it because it's throwing me for a loop. Okay. So here we go. So this is the infamous CourtTV thing referenced there with the link. And this is the video in which Hank Brennan represents that he mistakenly thought these were extrajudicial statements when in fact they were from a Zoom hearing. So let's just see what we think.
Her boyfriend, Boston police officer John O'Keefe, were bar hopping on a snowy night in Massachusetts. At the end of the night, they were invited to a house party at the home of a fellow officer in Canton, Massachusetts.
My
When
God.
Karen and John arrived, Karen
Like
did
Vinnie on all of the drugs. I was going to name a drug, but no, all of them.
not exit the car. John did. From that point forward, there are two very different versions of what happened. Prosecutors say Karen was mad at John and purposely struck him with her car and left him on the ground to
Heather, just so you know, Twiz has only got working with one arm, so you've got an advantage there.
die in the snow. But Karen and her defense team say John went to the party. Something terrible happened inside the house, and his body was placed outside, where he was found dead the next morning. Karen has been charged with murder, but claims she is the victim of a big cover-up by police. Prosecutors insist Karen Reed is a murderer, while she insists it was someone inside the house that night who was responsible for what happened to her boyfriend, John O'Keefe. And now another twist, a federal investigation into the way police handled this case. Tonight, we look at that federal investigation of the investigators and how it will impact
I'm
this
enjoying seeing another view of the courtroom.
upcoming murder trial. And we'll look at the crucial piece of evidence that Karen Reed's supporters say proves her innocence as we investigate the death of Boston police officer John O'Keefe. I'm Vinnie Politan. Thank you so much for joining us tonight. This story, unlike any we have covered in many, many years. I want to start tonight, though, talking about a case that we didn't cover here on CourtTV because it happened back in the 1920s. The case of Sacco and Vanzetti, two guys who claimed that we were framed for murder. These two guys were accused of an armed robbery turned into a murder. They were tried.
Very interesting. Okay. All right.
In the courtroom. They were literally put in cages as the evidence was presented. But from the beginning, they claimed they were innocent and they were being framed for what happened. You see, they were very unpopular because of their political beliefs. And in the end, they were convicted. They were executed. But 50 years after that execution, the governor of Massachusetts made a proclamation saying these two were tried unfairly. They didn't get a fair shake inside of the courtroom where they were tried and proclaimed them innocent men. Sacco and Vanzetti, an extremely famous and notorious case that divided the public. That trial was in Dedham, Massachusetts.
Wow.
Now in the same courthouse, in the same courtroom, Karen Reed is saying, I was framed.
Wow.
And this case too, dividing the community in Massachusetts. And now that this thing has struck with people across the country through podcasts, through this program, through
which tribe are you talking about?
What has happened inside and outside of that courtroom, and the bloggers and everyone else involved in this has divided the community around the country as to what really happened in this case. Now, when a criminal defendant claims that I was framed, you know me, I'm a former prosecutor. That's the filter that I analyze everything through. I take it with a huge grain of salt. But this case is a little different. There's something else going on here, literally going on. The FBI and the Department of Justice is investigating the investigators. While this case is still pending, there's an investigation on how this case was handled by police. The FBI! And you know, the entire case for the defense is that the police didn't handle this case. Police took evidence, moved it around, and framed and then covered up what really happened. Framed Karen Reed and then covered up the truth in all of this. That's what they're alleging. So in this case, there will be a search for the truth inside that courthouse in Dedham, Massachusetts, where Sacco and Vanzetti were tried, and now where Karen Reed will be tried. But it'll be a search for the truth not only of what happened to Boston officer John O'Keefe, but also a search for the truth of how this case was.
By the way, just to orient everybody in space and time, this is before the first trial.
Handled by the investigators. And today, another big hearing, and we heard something that I think for the first time, like we heard little bits and pieces about this federal investigation, but I want you to take a listen to David Yannetti, who is, you'll hear his voice. He wasn't in the courtroom, but was appearing via Zoom in this hearing in the Karen Reed case and gave the world, the judge.
Had Hank Brennan watched this, there's no doubt about it. Listen again, guys, this is my point. When he says, oh, I mistakenly and inadvertently said it was an extrajudicial statement, how? Listen, how?
First time, like we heard little bits and pieces about this federal investigation, but I want you to take a listen to David Yannetti, who is, you'll hear his voice. He wasn't in the courtroom, but was appearing via Zoom in this hearing in the Karen Reed.
In this hearing, even if he just had a transcript of this and didn't watch it, there's no question. This is insane.
Case, and gave the world, the judge and the rest of the world, an update on that federal investigation of the investigators.
You know what I think?
Take a listen.
You know what I think? I think we need to put Hank Brennan in one of them cages like they did for those two fellows in the 20s and have him tried inside a cage.
On that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reeve defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth.
The investigation is taking place now. As Karen Reeve is getting ready for trial on these murder charges, the feds are taking a look at the people who investigated the case and gathered the evidence that will be used against Karen Reeve. This doesn't happen, folks. This is extremely unusual. Let's bring in CourtTV crime and justice correspondent Matt Johnson, who is outside the Norfolk County Superior Courthouse.
So he does actually a good job with this. He's been there, boots on the ground. But we can get back to this part here where we hear from them
about the letters that the defense once released, communication between the DA's office, the U.S. Attorney's Office, and the DOJ. Here's a little bit more about that.
Oh.
Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation.
Funny, I remember hearing about this. This is before I was following the case, because again, this is before the first trial. I was like tuning it out because it was like all the people were fighting and whatnot. But now that I'm hearing this, like I remember people talking about these letters, but I didn't really know what the fuck they were talking about. But I remember this. That's really funny to hear this now.
As a result of his conduct in this case, those letters prove that he knew that even before the U.S. Attorney ever confirmed that there even was an investigation.
And those motions for sanctions and for the removal of the Norfolk County District Attorney's Office, that's going to be discussed at a later date. We'll talk about that. But after these statements were made in court, CourtTV got a statement from the DA's office saying that, wait a second here, we're not under investigation. Let's put it on your screen. They said this, quote, "No part of the communication with the Office of the United States Attorney yesterday or at any point has indicated that the Norfolk County District Attorney or any member of this office is the target of a federal investigation. Mr. Yannetti misrepresented that completely." The defense told at the court that the feds plan to release part of their investigation into this case, maybe with some discovery within the next couple weeks.
That's unbelievable that the feds are investigating the investigators, not the DA himself, according to the DA, but the police officers I guess the detectives that investigated the death of John O'Keefe. And now the results of their investigation will be released to the DA and released to the defense. So if they come up with something, if the U.S. Attorney's Office digs some stuff up, now the defense, Karen Reeve's defense, will be able to use that in their case. This is unreal, man. This is unreal what's taking place up there in Dedham.
It's unreal, and we still don't know the exact nature of the letters. They haven't been released. The judge actually had to get the letters from...
There's that dude again. We saw him representing Gretchen Voss. Oh my God, there's Lolly. Ew. There's some more of the hearing. So remember, Brennan said they made statements after the hearing. I don't know if that's true, because who knows? Could not be true.
And other people say that this case is about, right? Justice for John.
You know, it's amazing. You've got more people showing up from the public at pretrial hearings here in Dedham, Massachusetts, than were showing up for the effect, or what does this mean about what happened to John O'Keefe? Jennifer.
Well, that's going into the hearing.
Well, if if, and that's a big if, they have investigative findings that show some sort of...
Okay.
To die in the cold. The Apple Cocoa Core data indicates, or the core time indicates exactly what time that Google search occurred. That time was at 2:27 and 40 seconds in the morning on
Interesting elephant painting. What do you guys make of that elephant painting? That's honestly the thing. What do you guys think of that elephant painting? And the placement of the lamp underneath it is an interesting choice as well. Huh. What are you talking about, Heather? How can I not like Lolly? Easy. I don't know what you're talking about though, Heather. Unless that's maybe a Canton accent, then I'm not picking up on what you're there's a Lolly bird there though. What you're talking about. It makes you think of the moon. I can see that. Oh, okay, gotcha. Right. Gotcha. Okay. Makes you think of the moon. Yeah, it's interesting. Again, the placement of the lamp. Is it supposed to look like that? It looks like it's supposed to be on a pedestal. You know what I mean? Also, it's just kind of a funny lamp that it's that short. But anywho.
On January 29th. That's 3.5 hours before John O'Keefe's body was found.
All right, two sides to everything in this story, in this case, in this trial. Take a look at the screen. This is what the Commonwealth of Massachusetts is saying about all of that. The Commonwealth ran Miss McCabe's phone through a cell bright.
So that's clearly the part that he was saying when they gave some sort of an interview or whatever. So okay, my interpretation, Hank Brennan was misrepresenting this. There's no other way around it. Like, this is crazy. Oh, you didn't notice the lamp? The lamp is crucial. Hold on, let's go back and make sure everyone notices the lamp. The lamp is the best part / worst part. There you go. There you go, guys. Look at the weird lamp. Weird ass lamp. Weird lamp. So yeah, I don't know. Sanctions. I'm calling for sanctions. Sanctions. Hang them at dawn. Okay, so now we're gonna watch the juror interviews. This is the same juror you guys may have heard of. You may have heard that this happened. In other words, same juror that spoke out on Turtle Boy's show. But I'm curious. I have not actually watched this yet. I'm excited to see what questions Vinnie asks because we might get some different information. I mean, not that the juror will give different answers per se, but just what matters is the questions that are asked, right? And I really loved this juror. I thought this juror was very candid, and also I like her sunglasses in that picture. And the smoothie looks refreshing too. But he was very diplomatic in how he represented his fellow jurors, which was very commendable, right? Very commendable. Didn't throw them under the bus, even though he didn't agree with some of them clearly. So anyway, we did watch that interview, the one with Turtle Boy. We did watch that as well. But okay, so we're going to take a look and yeah.
Police officer John O'Keefe. Prosecutors charged her with murder, claiming she ran him over with her SUV on purpose. Jury deliberations began on June 20th. Following the mistrial, Reed's attorneys filed a motion to dismiss counts 1 and 3 of the indictment, charging her with second-degree murder and leaving the scene of an accident. They claimed that several jurors had reached out, indicating they had found Reed not guilty on these specific counts. On August 23rd, 2024, Judge Cannone...
We're going to skip past the background, because we know. There's the freaking lollipop.
Get a full understanding of what... Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. This is going to be a huge hour. Don't go anywhere. We're going to learn things in the next hour that we've been wondering about for months now. So let's begin here. The concept of double jeopardy in this country. You cannot be tried twice for the same crime, meaning you go to...
I love how Vinnie always has a graphic on the left with a thing underneath it. I will tell you guys, my favorite one of all time is, I think I have a screenshot of it saved somewhere because I was like, you're going to want to have this someday and there's going to be no other way to get this. It was like when Stephen Stearns got, for the Madeline Soto case, when he got they found all the crap on his phone and whatnot, right? Like this is early on or whatever. But then it came out that he had done an accidental factory reset and it had like a picture. This is my recollection. Again, I could probably try to go find it. I'm sure I saved it somewhere, but had like a picture again in this exact same square, right? It had like a picture of Stephen Stearns, and then in the box where it always has a label, every one of them, there's always a label. It said like Mr. and then in quotes, accidental factory reset, end quote. And it was the fucking funniest thing ever. Dude, I was just dying. I hope you guys can understand why that's fucking funny, but it might not be as funny without seeing it. But anyway, there you go.
Trial, you're found not guilty. They don't get another chance to prosecute you. All right. It's fundamental to our constitutional rights. Now, Karen Reed believes that she is being tried twice for the same crime. And she's really upset about it. The defense has been fighting about this because they believe the jury in her first trial came to an agreement on 2 of the counts of the indictment that she was in fact not guilty. That the jury came together and all believed the same thing, that she was not guilty. But she's being tried for all 3 counts. That trial is scheduled for April 1st now. Now, the defense didn't just sit back and let it happen. They filed a motion before Judge Cannoni, who
there were no shrinking violets, as Judge Bev said.
Denied the ability of them to get some form of relief. What they wanted to do was bring back the jury. They appealed it all the way up in the Massachusetts Supreme Court.
I just want to point out, I appreciate whoever was in charge of choosing the picture of Judge Bev, because look at the picture of Judge Bev. What do you guys think of that? What do you guys think of that?
Appellate court said no. No, don't bring back the jury. We don't want to hear.
Wait, post your greeting. What do you mean? Here? I'm not sure what you mean. I don't have a command for me, if that's what you're referencing here. There's not a command for me. Okay. Well, it's just so, but the picture, like, in other words, it's just kind of like Derples, like, as I would call it, like derpy, but like, I don't know, my friends and I in college, we called it Derples. It's like even worse. It's like more like Derples is like the extreme version. It's like look at her face. Like, look at her face. Like, in other words, it's not the most flattering picture of Judge Bev, shall we say? You know what I mean?
Hear from them.
It's all good.
There is zero interest from.
Payne has yet to let me know what he wants his command to be, so he doesn't have one yet. But I've asked only a bazillion times what he wants his command to be. So
The judicial system in Massachusetts about whether or not a jury agreed that someone was not guilty of murder, but didn't quite understand some of the instructions. They have no curiosity about what happened, how it happened.
Right. Rat, we could do something with the rat gate. What was oh dude, Heather with the rabies the other night killed me. Rat babies, rabies. We could do something like that. Rat daddy. Ooh, there you go. Yeah, that's a good one. Rat daddy. Yeah, we might have to go with let's fix everybody's commands a lot. Are you still having, like, what is the status with the rats? Is there more than one? Are they having babies? Are you giving them little scritchy scratches on the head and like carrots? I don't know. What food do they want? I don't know. What do they eat? Probably anything, right? Okay.
Inside that jury room, which to me is shocking. Because if there's an allegation of some racial bias, they're very concerned and they will bring the jury back. That's the law in Massachusetts. But if someone is found not guilty or potentially not guilty by a jury, no curiosity. Well, I have a lot of curiosity. I want to know what happened.
Me too.
And tonight we will. Joining me, a juror from the first Karen Reed trial.
Got his bow tie.
Joining us live tonight from Massachusetts, Ronnie Stanislaw. Ronnie, I know we've got about a second and a half delay here, so thank you so much for joining us tonight. We really appreciate it.
Thank you for having me.
Go, Ronnie.
Let me start
Ronnie.
right with the headline. I'm going to get right into it, Ronnie. Did all 12 of you inside that jury room agree that Karen Reed was not guilty of murder? Count 1 in that indictment.
Correct.
Okay, now let's roll up our sleeves a little bit. How did you vote? Was there a raising of the hands? Was there someone writing down what your vote was? Was it a secret ballot? How do you know, and how was the process that all 12 agreed that she was not guilty of murder, count one?
So we all raised our hands in terms of a vote, and we voted on that first count that we all agreed not guilty. Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
And the second count was count 3, and the same process where I guess the foreperson is asking for a vote and everyone raised their hands?
And everybody agreed not guilty for those 2 charges. That's correct.
Was there, they mentioned that you didn't fill out paperwork. Was there any discussion about should we check the box on the verdict slip?
So we didn't check the box on the verdict slip because we were still deliberating on the second charge of involuntary manslaughter, and that continued with deliberation. We did send out notes asking for clarification, but unfortunately we did not ask the question at the time, should we treat each charge individually and separately?
And the thing is it's not, this is the thing. It is not the jurors or the jury's job to know what questions to ask, right? We know that they could have asked the question, but the thing is, and we know that they had a discussion about it, right? And like, basically they were like, kind of like, you know, bullied into not asking or whatever. But the point is this, that the jury instructions should make it more clear. And Judge Bev, we covered that extensively. And the way Judge Bev read those jury instructions, honestly, when we looked at it, the way she read it, it did make it seem like they had to have a verdict on that first count before they could go on. Like, in other words, it was clear the way that she read it, that their instructions were clear as to how they had to go about it. But the way that that was communicated is not actually factually reality. They don't have to do it that way, but that is 100% how she communicated it. So yeah, problem.
So explain to us why the presumption was that you had to come to a conclusion on all 3. Was there any debate among the jurors about whether or not we have to agree on all 3 counts, or it can be just 1 count, or it can be 2 counts? Was there any discussion or debate amongst the 12 of you about what the rules were when it was time to fill out the verdict slip and determine and let everyone know where you were in these deliberations?
So one of the big things that happened was we all agreed and voted, and we kind of not came back to any of those charges. We never revisited them because we had already voted on them. And then we kept on debating on that second charge. And because we kept on debating on that second charge and deliberating, it that kind of got us caught off guard at the end in terms of how to respond to that and whether to ask. There was a couple of us who did clearly indicate that maybe we should ask about treating each charge independently, but the majority overruled. And essentially, we were left to believe that it needed to be all or nothing.
See, that's interesting. See, that's fascinating. That's something I would think the folks in Massachusetts would be interested in, is that now you're talking about there's debate about the rules within the jury. See, I look at that's the fault of the system, not informing you ahead of time about these things. Okay. So let's go through, because you all sent out notes. I want to put up the first one that was sent out. I believe this was the one on Friday. Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive—
Good. You know, I don't know that Turtle Boy, I'm trying to remember because it was a long interview. I don't know that Turtle Boy asked him specifically about each note. I'm glad that he's asking him this. See, this was what I was wondering. I was like, I bet we're gonna get some different questions here.
Review of the evidence and our diligent consideration of all of the evidence, we have been unable to reach a unanimous verdict. So that first note from Friday, which I believe is actually the second note that you had sent out, what was the status? At that point, had you already finished on 1 and 3?
To my understanding, on Friday, we had already finished on 1 and 3, and we were stuck on that second charge.
So when you all sent that note to the judge, what type of response were you expecting? Did you have any expectations about what would happen after you sent this note to the judge?
The expectation was she probably is going to send us back to continue to deliberate given the circumstances. So that's where it stood.
Okay, and I always wonder about that, right? Because I cover trials for a living. I know the judge is going to send you back, but I never know what, folks who don't watch trials all the time like I do, or have practiced law, if they expected that. But those were your expectations that, listen, we're stuck, but we know we're not done here, so we're going to have some more work to do. Let's get to the second note. So this is now, that was Friday, come back on Monday. I think this is Monday around 11 in the morning or so. The second note, it's actually the third jury note, but the second deadlock note. Judge Cannoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds.
And I mean, the deeply rooted
at that point,
so
sending that note,
right?
what were your expectations and the expectations of your fellow jurors about what's going to happen after you send this note out?
I think at that point we knew it was an impasse because we were stuck. We were continued to deliberate, but despite continuous deliberation, as clearly indicated in that note, there were beliefs that were not going to be changed. And as a direct result, we could not find essentially a decision that would be unanimous. And therefore, it would be a futile exercise in terms of, and that's the unfortunate thing, is it wasn't clear that that was only on one charge. It clearly is indicated by all those notes. It seems like we were in deliberation and we were in an impasse on all three charges, but that was not the case. And unfortunately, we never asked that question to treat it as three separate charges independently of each other.
So when you send this note, were you expecting that this was going to be the end of the case, that everyone would be going home after this? Were you expecting anything else to happen, any other sort of response from the lawyers, from the judge, from anyone after sending this note out?
In my mind, no. I believe that was it. We were going to be done, and it would be a decision from there that it would be a mistrial. But that was in my mind. I don't know, and I cannot speak for the other jurors.
Absolutely. And again, thank you so much for joining us. The folks who watched the trial, invested in it, and are very confused by all of this. This is really opening up a lot of eyes. Let's take a look at the final note. So this is the one later on that same day, on Monday, the final note. We continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Now, a lot of people have focused in on two words that were written twice in that note: the charges, the charges. Everyone who's looking at that is saying, well, they were talking about the charges, and there's three charges in this case: count one, count two, count three. So why was it written the elements of the charges? What was that supposed to represent and mean in that note?
Yeah.
I think during the time frame, it was still very clear to us, or at least the majority, that it had to be all or nothing. Again, not treated independently of each other, and hence the verbiage that was utilized in those notes indicating that it should be charges, because again, we as the jury were treating it as such, that it had to be all or nothing for all three charges, not to be treated independently of each other.
I get it. I get the mindset. All or nothing, the charges are the charges. If we don't come to a conclusion on all three, then we're having trouble dealing with the charges as opposed to saying the charge or count two. Let me ask you this. As you all were focusing in on that second count, what was the debate there? What were you looking at, and how close were you? What charge were you considering in that second count?
I believe that most of us felt that she was operating a vehicle under the influence of alcohol, and that played into it. However, to some individuals, there was reasonable doubt on the mechanism to which Mr. O'Keefe actually succumbed and died. So I think that had a play as well. So those were some of the factors that were being discussed in that jury room.
So it's 12-0, 12-0, not guilty on 1 and 3. let's go to count 2. What was, by the time you finished, after all these notes and the deliberations, what was the split, and how many, and what exactly was each faction voting for?
Speaking of goals, I've noticed that like YouTube has like this beta thing they're testing or whatever, and only certain channels have it, but there's like a goal thing. So I can't see it on StreamYard, but I think you guys can probably see it on YouTube. I don't really know. I think it's like, I know Runkle uses it, but apparently there's like a goal thing. So let me know if you guys are interested in trying that out and whatever the fuck it does.
It kept changing. At one point in time, it was split 50-50. And so 50-50 initially, 6-6, then started to, based on debate and deliberation, it became clear, and we all kind of agreed that she was operating, or anybody for that matter, if they were operating a vehicle during that time frame and with all that alcohol, was probably under the influence of alcohol and should not be operating a vehicle. Then it changed to between 8-4 versus 9-3. And ultimately, I don't think we came up to a final conclusion on a final tally as a direct result of it continued to be stuck. And it was very clear that some people were under the mindset and the belief that she was not guilty. And so at that point, those notes were continuously passed, ultimately with the final note. And
I've heard different things at different points about what the guilty votes were for. Was it for the top count of was it for the top charge in count 2, or any lesser included charge within that second count?
For the super chat.
So it was, I'm sorry, can you clarify the question? I just want to make sure I'm answering it.
Sure, absolutely. So within count 2, where you have 6, then 8, then 9 people believing she's guilty, was it guilty of the charge in count 2 or a lesser included charge within count 2?
It was a lesser included charge within count 2 at one point.
Okay, we've gone through the deliberations. When we come back, Ronnie, what I want to do is go through some of the moments and some of the evidence in the case and get your perspective on all of it. This is really eye-opening. Ronnie Stanislaw is going to stay with us the whole hour as we continue taking you inside the jury room in the Karen Read trial. We'll do that, plus coming up next hour. Tonight on Vinnie Politan Investigates, the murder of 13-year-old Madeline.
So I think you can make the goal whatever it is that you want. So you guys let me know if you want me to set a goal. There's Sarah Boone. Oh my God. There's OJ. Oh, he's back to the questions. Okay.
State of efforts with regard to Mr. O'Keefe. What, if any, observations did you make of Ms. Reed and what she was doing or saying at that time?
Ms. Reed was visibly upset. She kept saying, this is all my fault. This is my fault. I did this.
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him.
You indicated that the defendant said, I hit him. Is that correct?
Yes.
That's something that she said once or more than once?
3 times. I hit him. I hit him. I hit him. Earlier, it was could I, did I? When she spoke to the paramedic, it was crystal clear. I hit him.
And there were more witnesses that said the same thing. And prosecutors argued it was a confession by Karen Read that she struck John O'Keefe with her car. What did the jury think of that? Still with me, a juror from the first Karen Read trial, Ronnie Stanislaw. So, Ronnie, did you listen to those witnesses and did you hear a confession from Karen Read? And do you believe that she confessed to striking John O'Keefe with her SUV?
I did not hear that. I mean, to me, it was not a confession. I believe in a moment when somebody's stressed, they may be saying things. We kind of the group found it interesting, and I found it interesting that that was what everybody kind of remembered, when usually in the heat of the moment and the stress of the moment when taking care of a patient, you focus on taking care of the patient and not necessarily what others are saying in the background. So we looked at it, but we moved on from it.
Interesting. Let me just follow up on that for a second. Do you believe that they were coached into saying that or misremembered? What do you think?
I believe that at the time, certain people may say things. I don't know, honestly. And speaking for myself, I could say that I did not put any merit in it. And there may be some sort of coaching or kind of rehearsal, knowing full well that you're going to be testifying. But again, in the legal system, I don't know how that actually works out in the end to the jury. But the jury obviously some individuals can take it as such, and some people can actually look at it as something differently or dismiss it.
Interesting. I mean, are you a paramedic? So you have some experience in dealing with folks?
Yes.
Oh, so that's what I love, when jurors bring their own life experience in and can mix through and parse through some of the things and apply a little common sense to all of it. That's awesome. I want you to take a listen to the two medical examiners now, because that testified in this case about the injuries and what they signified. Let's take a listen.
The cause of death was due to blunt impact injuries of the head and hypothermia. When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs.
Would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Are every injuries from a pedestrian collision the same?
No.
Are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal.
Based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm,
yes,
directly, I would say no, it doesn't look like that at all.
Okay, Ronnie, let me ask you. You had those medical experts. You had the trooper who testified about the pirouette, as described by Alan Jackson. You had the experts that were brought in by the defense as well, called by the defense. Did any of this evidence convince you one way or the other about whether or not John O'Keefe was struck by a car, that the injuries were consistent with being struck by a car?
This is where we debated for hours. And so some of us believe that there was injuries there, and the injuries were after Karen had dropped him off, and therefore those two individuals were there at that location, and ultimately John O'Keefe was dead in the front lawn. And so for some of us, it was conclusive evidence that she was guilty. For some of us, though, the injuries were not consistent with a pedestrian struck per se. It wasn't the standard. I understand that there may be different mechanisms, but there was not enough evidence or testimony given on how it could be not the standard pedestrian struck with extremity injuries. And so it seemed inconsistent. So for some of us, it solidified that essentially it was not a collision with the motor vehicle that ultimately caused the blunt force trauma to his head.
And which camp were you in? Did you believe it was the car, or did you believe it was something else?
I believe that it may be something else. So it was not, it created reasonable doubt as to what they were presenting as the evidence in the testimony.
What did you think of the cuts on the arm of John O'Keefe? Did you believe it could have come from a dog?
Again, it wasn't conclusive. To me, it wasn't conclusive whether it was an animal or just abrasions due to glass or scraping against metal. But there was no conclusive evidence on where it actually originated from and where those scrapes or abrasions, how did they get there per se.
Okay, let's talk about the tail light of the SUV. It was broken. It's clear it was broken.
Before they get into that, so Heather was asking about the lesser includeds on count 2. I don't remember specifically, what the elements were and what the lesser includeds were. That in the way that one could find that, it would be going back to the different live stream. Well, at least in terms of the way I would probably go about trying to find those verdict forms, right? Would be, we covered those on the live streams at the time, and we went through those at length, but I don't remember how that was laid out on the verdict forms. And the verdict forms were really fucking confusing as well. But I just remember that there were 3 lesser includeds for count 2.
Broken. I'll start with your perspective. How do you believe the tail light was broken? What caused that?
Some sort of impact, clearly, that caused the breakage of the tail light. I think
he didn't have a jacket. He had like a long sleeve, kind of like a long sleeve tee with like a hood, I believe, and then like a t-shirt underneath that. And they did show it, I believe, but it wasn't a lot. Like, it wasn't like they showed it a lot. I think they showed it like once when they were just like, you know, going through all the different evidence. And it might have been when Trooper Buchanan was on the stand. Because I know there was also the whole thing about the chain of custody with getting the clothes from the hospital. But yeah.
In terms of testimony, we would have preferred that the Dighton police officer who testified clearly indicated a little bit more information on whether the broken taillight was consistent to when he first saw it at the location at the Reed's residence versus, and then it was towed. And then also it would have been nice to have some sort of testimony from the tow truck driver who transported it to the Canton Police Department, because in that sense, we would be able, whenever you move a vehicle, usually you take pictures or note any damage. So I would imagine that that tow truck driver probably would have had some sort of information, unless he did not do due diligence and actually write down any kind of damage on the car prior to moving it to the Canton Police Department.
So I want to show you what we call the Sallyport video, which is when the SUV is brought into the Sallyport. It was presented in two different ways, right? On the left, the prosecutors brought it in that way, and it was inverted, and it was backwards. So left is right, right is left. So when you're looking at the right tail light in the exhibit presented to the jury by prosecutors, it's actually the left tail light. Did that bother you? Were you offended by the fact that the video presented by prosecutors actually inverted the video and made left right and right left, and they didn't tell you about it?
It was quite confusing, because when we actually looked at it, we said, oh, the tail light is intact. Versus when you look on the other side, there seems to be some sort of damage potentially. So it did kind of affect our thoughts, but ultimately we tried to look at the timeline, and if it was possible that there could have been some tampering with the vehicle prior to its arrival to the Sallyport, but we kind of dismissed that and moved on, kind of looking at the overarching information that there was an injured individual who ultimately died on the front lawn. There was a motor vehicle with some sort of damage to it, and somebody who was operating the vehicle who was clearly indicated to be under the influence of alcohol.
So from your perspective, you moved on and didn't really determine one way or another if Trooper Proctor or anyone else tampered with that taillight?
We didn't feel like there was any tampering per se, because of the fact that it didn't seem like there was the appropriate timeline to actually do some tampering and then get it to the lawn or the crime scene within the correct time frame.
Gotcha. Wow. What a great jury. Thoughtful, smart. Ronnie Stanislaw is going to stay with us. We got you in lockdown for the hour, Ronnie. You can't go anywhere. Thanks so much. We're going to continue this conversation because there's more evidence and some more questions like, does Ronnie believe justice was served? Everything that has happened on social media, in the local community, and obviously at the courthouse. Let's bring back in our special guest tonight, a juror from the first.
Pat Randall, happy to see you again.
Karen retrial, Ronnie Stanislaw. Ronnie, did you guys have any idea, did you personally or other jurors have any idea about what was happening outside the courthouse? I mean, the dozens and dozens of people, many of them wearing pink, that were there day in and day out.
We did not allow them to distract us in any way, shape, or form from our charge and what we were responsible for doing, which was to listen to the witnesses, the testimony, and the evidence, and deliberate and ultimately try to come to a conclusion. So we did not allow that to distract us in any way, shape, or form.
But you guys had an idea that there were a bunch of folks there and they're very passionate.
We could hear them at times, obviously, but again, we didn't allow it to distract us from our job at hand.
Fantastic. Let me ask you a couple of big questions here. And we discussed that you all came to a 12-0 not guilty on counts 1 and 3, which is enormous. You invested a lot of time in all of this. Who is at fault for this confusion from your perspective? And this confusion that you guys did your job, you came to a verdict on 2 of the 3 counts, yet somehow, some way, it all slips through the cracks. Like, who's at fault, do you believe?
I think that we were responsible as the jury because we did not ask the right questions. I think there's always the justice system. We're not professional jurors, and we don't know the justice system like lawyers would know and those who are in the system. So some instruction would have been great, but I think moving forward and knowing this, I think people need to know that it's okay to ask questions. There's nothing wrong with asking a question. And I don't know if we were just intimidated as a jury to be asking and not feel stupid, for lack of a better term, to ask the question that could we have looked at the charges independently of each other. So I think we unfortunately failed the system to ask that, but it could also be a combination of the system not giving enough instructions. Again, like, we are not professional.
And very diplomatic of him to not say Judge Bev, right?
Jurors. This is something that people don't usually do and don't know exactly the rules. So shame on us for not asking the question, and shame on the system for not could be clearly indicating what can be done.
I don't think they need to be putting the blame on themselves. It's the system.
Can't be done.
Well, let me just say, Ronnie, no shame on any of you. No shame on any of you.
Replay?
You get called down.
You want me to replay? You want me to replay something from the video, Kane? I can back it up. You want to see, are you wanting to replay the part with the person dressed up as Judge Bev? I'll back it up here a minute. Let me know.
So I think we unfortunately failed the system to ask that, but it could also be a combination of the system not giving enough instructions. Again, like, we are not professional jurors. This is something that people don't usually do and don't know exactly the rules. So shame on us for not asking the question, and shame on the system for not could be clearly indicating what can be done and can't be done.
Well, let me just say, Ronnie, no shame on any of you.
Yeah.
No shame on any of you.
Thank you, Vinnie.
You get called down there, and you are 12 who invested all that time. You are the 12 who didn't come up with some excuse why you couldn't do it. It's your civic duty. It's shame on the system. 1,000%. I'll answer that one for you. And I think you're just being nice. And
he is being nice.
Let me ask you this, though. What is the takeaway from you, having gone through all of this? Do you feel that there's an injustice now going forward in this case? Do you feel disappointed? Do you feel angry? Do you feel confused? What is it that you're taking away, having gone through all this and seeing the way that it sort of ended up?
I think disappointment in terms of not having to provide closure to the families and to everyone. I think we were tasked with a duty, and we didn't provide any closure at the end. I feel like it is going to be another extra resource when, if we had just clear direction at that time, we would be able to make a decision on 2 of those counts, and therefore this might not be a conversation that we may be having. So unfortunately, it is what it is, and I understand also why they do not or have not approached us to look at what went wrong. Because in terms of now looking back at it, we've been out too long to know or investigate further on our own. And that would have tainted the evidence and ultimately the deliberation process of the vote. That's why deliberation is very specific. And that's when the first time we're supposed to look at the notes and the evidence and debate amongst ourselves and not with others. So I can see how that's ultimately where we are. I just hope that in the future, there is now hopefully direction, a little bit more direction and clear direction so that it can be looked at as individual charges. And I'll be interested to see what the results are, but it may actually remain the same in terms of the 3 charges, right? I think
it looks that way. They've gone to federal court, so it could change. A federal judge could step in and have some curiosity. Let me play something for you, because all those folks in pink, this was one of the big issues for them initially when this case was being investigated and Karen Reed was being charged. It was about a Google search that was done by a witness named Jennifer McCabe. Let's take a listen.
You see this first search that says HosLongGate cold?
I do.
What's that time?
You've got the, it's right over at 2:27.
AM or PM?
AM.
Ms. McCabe, you made that search at 2:27 a.m. because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time.
You
No.
realized the next morning, after John was discovered, after 6 a.m., that you had an incriminating search on your phone, didn't you?
Absolutely not.
To cover your tracks, you searched it again in order to overwrite the original search at 2:27, correct?
Again, absolutely not.
Okay, Ronnie, your thoughts about the Google search?
I wish we had more testimony in terms of how it actually acts. So an expert to say, when you do a Google search at 2 o'clock in the morning, it's there. And even if you search it again at another time, it's supposed to always be there and it's part of the history. If there was some sort of other expert who kind of would talk about that, it would have been great for clarification purposes. But again, not enough conclusive evidence for some of the jury to convict or not convict.
Let me play something else for you. Here's Alan Jackson cross-examining the lead investigator from the state police. I know you know who I'm talking about, Trooper.
Oh my God. Before we get into Trooper Paul. So I wanted to mention, speaking of, where is it? Speaking of Fievel, Trescott, Mouskowitz, SDS has a show they do every Friday where they also have the same two guests on, Phil and Scott. And Phil's a retired detective, and Scott was like with the FBI and maybe the CIA too. No, just the FBI maybe. But anyway, so they but what they were doing, I guess, on Friday, and I think I was actually streaming at the time because I missed it, but I was listening to it today when I was running errands on replay, and they were watching Wendy's interview. And I think they actually knew like literally nothing about the case. So Joel gave them just like a quick little rundown, and they just were watching the interview, Wendy's interview cold. And it's going to be in like multiple installments. And dude, it was freaking amazing. But the thing that was so funny is because I was driving, I couldn't look at the live chat replay, but I'm pretty sure fucking Glenn was there because there were comments that were coming up that Joel was responding to out loud so I could hear it. And he was saying, he said something like, oh, there must be a couple Wendy fans in the chat. And you know, they're thinking Wendy's innocent, stuff like that, etc. There were a number of comments made, and I was like, oh my God, it's gotta be Glenn. It's gotta be Glenn. But I will say that their reactions were priceless. Absolutely fucking priceless. Like, again, without knowing anything about it, except for just like a brief overview, right out the gate, they were like, dude, it was awesome. So it might be something that we might want to watch some of at some point. If y'all just let me know, because we've watched those interviews several times, but it's really interesting to hear how like their perspective with like their experience doing interrogations and stuff and like perceiving the body language. And anyway, it was really interesting. So there was some, I thought it might be something we might want to look into, right? Yes. She had a whole delicious lunch for sure. Fievel, Trescott, Mouskowitz.
Alan Jackson cross-examining the lead investigator from the state police. I know you know who I'm talking about, Trooper Proctor.
Oh, Trooper Proctor.
Trooper
Proctor. I was thinking it was new Trooper Paul. Damn it.
And Karen Reed had struck this officer with a car, gave you license to call her a
It was my emotions that got in the best of me.
and you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection.
Wally.
Okay. Ronnie, do you think Karen Reed was treated fairly by Trooper Proctor in leading this investigation?
His behavior was not very professional. And so
again, you can just hear it. He's so diplomatic of him, right? Jesus.
His testimony was treated as such by some of us because of that damaging information. That being said, he was not the, we looked at the evidence as a whole, not necessarily just that one piece, but definitely unprofessional and unbecoming for somebody who is in law enforcement and in a position of power.
Right.
Okay, we only have a little bit of time here. What do you think happened?
I honestly do not know. I know that ultimately there was some sort of blunt force trauma sustained by Mr. O'Keefe. He ended up on the lawn and he succumbed to his injuries because of the cold and hypothermia. What brought him there, I do not know. Other than Karen Reed and John O'Keefe came to 34 Fairview.
We'll go back.
And then from there, what happened and what transpired, I do not know. Other than John O'Keefe died and Karen was able to drive home and then ultimately came back in the morning.
Yep.
So again,
that's reasonable
I don't
doubt.
have clear vision.
Yeah, that's reasonable.
Yep.
Ronnie Stanislaw, amazing. Thank you so much. Thank you for your service and thank you for shedding a lot of light on what has really become a very divisive and confusing case. Ronnie Stanislaw from the Karen Reed jury. When we come back, something else you need to know tonight.
Join CourtTV's Vinnie Politan with the Politan.
He's found unconscious after crashing his brutal murder.
The vision.
Time to reveal something else you need to know tonight. Take a look at the big board. Guilty on all counts. That's Marshall.
Okay, never mind. Okay, so I'm going to go back real quick as per Kane's request to find the Judge Bev robe outfit person. Somewhere in this vicinity.
We could hear them at times, obviously, but again, we didn't allow it to distract us from our job at hand.
Fantastic. Let me ask you a couple of big questions here. And we discussed that you all came to a 12-0 not guilty on counts 1 and 3, which is enormous. You invested a lot of time in all of this. Who is at fault for this confusion from your perspective? And this confusion that you guys did your job, you came to a verdict on 2 of the 3 counts, yet somehow, some way, it all slips through the cracks. Like, who's at fault, do you believe?
I think.
There we go. There's Judge Bev. Dude, freaking hilarious, right?
We were responsible as the jury because we did.
Great question here from Kat Randall. Did this become a debacle or a kerfuffle? All of the above, I would say. All of the above, I would say. We have to do this. Hold on. Hang on. First of all.
It's very big. Yesterday, I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendy made another new friend? Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know? Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just come
I'm
up?
going. Sorry. Heather says, I met a new friend on a walk. Bitch, how old are you?
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys. Andy's friend, the fucking mortician. What is happening?
I ate a lunch. Like, I had a whole delicious lunch.
Oh my God. It's so good. I have so many. Those are like maybe the top ones though. Dude, I know it never gets old. I totally agree. Totally agree. Yeah. I have no idea. I'm sure somebody knows, like somebody in the school crew probably knows, I would think, but that person's not here right now. Maybe they will be on replay crew and they can let us know. Twiz is counting the days until he meets a pretty mortician. I'm rooting for you, Twiz. Fajitas. Oh. Yeah, we don't know. Did we pull up the menu for Mosaic? I can't remember if we've done that because we know that's where she was eating at. That's where she was eating. Let's see here. It's permanently closed. Interesting. It says it had an inventive American menu. Now, we know she had when she was with a friend and she went to the food truck. I think that might have been tacos, but it looks like Mosaic was American food, which, I mean, can be like anything, right? Like, what do you guys think of when you think of American food? Like burgers? I don't know. The way they spell mosaic, it seems like it's fancier. You know what I mean? Mozaik. Like, I don't picture burgers there. Can we look up who the mortician? Dude, I'm having flashbacks to the Office episode with the chair model. That's what that reminds me of. What was it? Elizabeth? Did she give a last name? I don't think she gave a last name, though. Yeah, when Wendy is arrested, when I was in the shower, not even joking, I was like thinking of all of the things that we've said we were going to do when Wendy gets arrested, because there's like a long list. We're going to add that to the list. A reboot of Twizzle's Drunken 12-Hour Live. Yes. Maybe Twiz can come on and we can do an actual new. We could do a back-to-backer. We could do a reboot of the 12-Hour Drunken Live, and then we could do a current Drunken Live potentially. But also we're going to definitely do the Wendy song with the music video with all of the different moments. I already have that in my head. It's going to be amazing. When I can email her in prison to like math. There you go. You know what's so funny? I think the reason why STS decided to even play the interrogation and do it in installments every Friday so that Scott and Phil can weigh in on it. I think it's literally for the same reason that we first started watching it, which is because it's literally in anticipation of Wendy's arrest, which is really fucking funny. Because I started doing that in freaking, end of December. But anywho, yeah, no, I mean, y'all can both come on. Y'all can both come on. Anybody that wants to. So far, I've had one guest, Denise, because when she was boots on the ground for the hearing, but totally could be a party, a celebration of justice, as it were. The fourth extortion inception, dude. That's going to be her theory for real at trial. That will be her theory. Wendy, if you're listening, there you go. That's your ticket. The fourth extortion inception. Yes. Twiz, I'm pretty sure you were there. I'm sure you were there. You were definitely there. Yeah, Denise came on because that was when she was there for the hearing, boots on the ground. And literally, I literally didn't even know how to have a guest on, and she didn't even neither of us knew what we were doing, but we made it happen, and it was great. And she talked about everything that happened that day and whatnot, and she was just using her cell phone and gave us her perspective, talking to the Gonsalveses and everything that she saw going on and how they thought they were going to be let in and then they weren't and everything. But that's the only time I've had anybody on. But now I know it's easy. It's fucking easy. StreamYard makes it easy. So yeah. And she came on and then she said she was going to go do something and she'd be listening in the chat or she'd be in the chat, but then she came back on for a minute and then she left again. Anyway, it was great. So, but yeah, that was the day, whatever day that was. I guess it was the 23rd, January 23rd, I think maybe. That's so cute. Puppy sleep barks. I love it. I don't have mods. It's just me and Nightbot. Unless you're talking to somebody else. Snapping at the armrest. Maybe you're talking to somebody else. Maybe you're talking to being a mod for Heather or something. I don't know. Although Heather doesn't go live. So Heather, why don't you go live? Make us any. Well, it is. You mean StreamYard? Having people on? It was easy. I don't even remember how I did it, but it was super. I'm sure I could duplicate it. Oh yeah, you hit the invite. Yeah, it's easy. And then I just messaged her the link on Discord, and she clicked the link, and then there she was. So what we're going to do is we're going to have here shortly in 20-ish, I think I have it scheduled for 2:15. So in 25 minutes or so, we are going to have the bad mic was a StreamYard issue. because I've not changed anything. I just use my computer. So that was StreamYard issues, and I remember everybody else's audio was fucking up. So that was StreamYard glitches. That was not my microphone, because my microphone is the same, but I'm glad it's better nonetheless. But yeah, so what we'll do is in like 25 minutes ish, we're going to have BK. So we're going to be covering all of the IGG motion in limines, of which there are 3. And I think we're also going to be doing the DNA under the fingernails, and then the biggin, as they say, the big motion to strike the death penalty. That's like the all-encompassing one. Or it's not actually a motion to strike the death penalty. It's a motion to preclude. It's similar as what they did for Lori Vallow, right? And they were successful there. So that's hilarious. We did autism last night, Twiz. You were there. We did autism last night. We finished with the autism. We did all the autism last night. So I guess the cool one, I don't know why one of them's cool and not the other, but yeah, the other one. So I'm going to just get the piglet situated and put some laundry in the dryer. And then I will be back and we will go through the next batch. I think it's part 4 of the chipping away at these motions in limine. And we are all up to speed on the latest Karen Reed docs as of now. So that's good. I would imagine we might see some more stuff as of tomorrow because there's still a lot of motions on the table. But anywho, so right. Says he ain't taking. Yeah, I wouldn't expect him to take a plea for sure. Kane will be back for the shower curtain. And it's interesting too, because like in regards to the plea thing, right? Remember we read in the last night with the autism that one of the things that she referenced was like how people with autism spectrum disorder have a harder time participating in their own defense and making tough decisions. And one of the examples she gave was like taking a plea, which doesn't mean that she was encouraging him to take a plea. I just my brain, we hadn't really heard it. The reason I thought of it is because we haven't heard that really mentioned from the defense attorneys in this case. That was the first time I'd ever seen it referenced that I can recall in any of the court filings. So that's why it stuck out to me that it was even in a, it's like, oh, that's the first time I've like seen that word, right? In any of these filings. But that was just one of the examples that she listed in terms of how it can affect their ability to prepare for trial and participate in their own defense. TJ Maxx. I've like literally never been to a TJ Maxx. Okay, so love you guys. We will be back here very soon for the next one. So love y'all, and I'll see y'all soon. Squirrel out.